Welcome back, everybody. It is day 2 of trial in Laredo, Texas for defendant Ronald Burgos-Aviles. The former Border Patrol officer faces the death penalty in a double homicide that prosecutors allege was over child support money. Burgos-Aviles had a child with 28-year-old Griselda Hernandez. At the time, he was living with another woman with whom he also shared children. In March of 2018, Hernandez reportedly served the defendant child support documents at his workplace. A month later, police say the defendant asked Hernandez to see their almost 2-year-old son, so they set up a meeting in a remote area near a park. Prosecutors believe that the defendant stabbed Hernandez and the little boy to death on that visit to avoid child support responsibilities. Burgos-Aviles is pleading not guilty to capital murder charges. The first witness for the prosecution on Monday was the victim's sister, Angela Hernandez. She told the jury she expressed concern time and time again over the victim meeting with the defendant over their frequent conflicts about child support. Hernandez recalled one of those meetings where the baby ended up with a presumed spider bite, but the chief medical examiner who took the stand after Hernandez determined it to be an injection wound from a needle. On Tuesday, key testimony came from Agent Bradley Dennison from Laredo Border Patrol. He responded to the 911 call by the defendant and described the defendant's behavior.
He was just walking up and down, back and forth, both towards me and then turn around away. He went back and forth maybe about 3 times, and then he proceeded back towards me. As the EMTs were working on the female, past them. As he proceeded past me, he sort of scuffed his, I'm sorry, not past me, towards me, past the female's body. He scuffed his feet a few times, and then he made contact with that large rock that I mentioned that was covered in blood. He caused that to roll maybe a foot or 2 down the road.
And that rock in relation to where the body was?
It was within a couple of feet of her feet.
Did Agent Burgos inform you that he had found or had in his possession the cell phones of either of the victims?
No, sir, not at all.
Did he ever at any time inform you that he knew who the victim's identity was?
No, sir, not at all.
Did he at any time make any statements as to what he thought had happened there in your presence, yes or no?
No, not in my presence. He never mentioned that he knew her at all or recognized her or anything.
Let's start with that. Philip, how impactful is testimony about how the defendant reacted at the scene? Is it fair for someone to judge his responses when they don't know how he reacts to other things?
Exactly. You got to understand, there is no playbook for human reaction and human emotion, particularly when you have people who have served in the military, peace officers, border patrol folks. They're very stoic, stolid folks, and sometimes they don't wear their heart out on their sleeves, and they tend to suppress a lot of their feelings and emotions. Not to mention, to be fair to him, he may have been under suspicion immediately once they heard of the connection between both decedents and him. So he absolutely had the right to clam up, and to hold that against him, I think, is unfair.
Well, Brian, lying at the crime scene, it almost reminds me of Alec Murdaugh lying about being at the kennels. I don't know if that's similar, if you think it's different. Do you think it's going to have the same kind of outcome for the defendant here?
I think it will, and this is why. For everyday interactions, we would say once a liar, always a liar. If you're willing to lie about this one thing, why would you not lie about other big things? And Phil would like this one, falsus in uno, falsus in omnibus. It's the legal concept of if you are false in one thing, you are false in all. And it applies to everyone, witness, defendant. And so if you lie about a little thing, I think it's going to make it that much harder for the jury to believe him on other things. Because if he's saying, oh, I don't know this woman, I just came across her being dead, and now you find out that you had a relationship with her, that there was child support, that there was all this stuff, the question becomes, why are you lying about that? And the general, basic, probably easiest answer is, because he was hiding a murder. He did not want law enforcement to know his connection to this woman, to this decedent, because he wanted to hide his motive and the fact that he murdered her. Now, is that true or not? I don't know, but a lie definitely doesn't help to prove otherwise.
But interestingly enough, we've seen defendants take the stand and admit to lying and to lying before in the past. It doesn't mean they always are convicted. It's very fact intensive. It's just because they might even admit that they were lying or they're caught in a lie. Jury holds it against them, maybe not all the time. When we come back, investigators accuse a woman of trying to abduct a child by pretending to be a worker from CPS. We're looking at her upgraded charges by the grand jury and what the boy's father had to say about the chilling encounter. All right, welcome back, everybody. We're wrapping up today's show with an update for you on the Ohio woman accused of posing as a social worker and approaching a child. A grand jury has officially indicted Lisa Necrelli, charging her with attempted abduction, impersonating a peace officer, and burglary. Jamie Spradlin says her 4-year-old son was playing in the front yard of their Cincinnati home when Necrelli apparently approached him. He went inside and told his mom that a lady wanted to speak with her, and later said the stranger told him that she wanted him to come with her. Necrelli told Spradlin that she was a Child Protective Services worker and showed some type of badge. Necrelli ended up entering the Spradlin home to inspect it and even spoke with Spradlin's other children. She told the family that she had reportedly gotten a complaint, but when the family contacted police, they found out that CPS had no record of Necrelli or, of course, any complaint against the Spradlins. When police arrested Necrelli, she reportedly told them that she had been drinking and wanted to teach the family a lesson for leaving their 4-year-old unattended. Necrelli could face more than 12 years in prison if convicted. The family says Necrelli not only approached their young son, but also touched him while they spoke. Tim Spradlin says the encounter made his son very uncomfortable.
It's sickening. Why was she rubbing our child? Why was she touching him the way she was? If it was her proclaiming that she thought a child was outside alone, then why did she look at the other neighbors around and the other child on the porch next door that my son was playing with? And why would she just stand there and keep touching him instead of knocking on a door? Say, hey, is this your child? He wasn't doing anything wrong. He was on his bike in front of his yard.
Philip, how is that the prosecution went in with one set of charges and the grand jury came back with higher charges?
The general role of the grand jury is to investigate whether or not a serious or violent crime has been committed, namely a felony. And they can distill from the evidence presented at the grand jury proceedings whether or not the crime can be proven based on probable cause, and if so, they return a true bill of indictment. It is of no moment whether or not the charges were presented to the grand jury by way of formal document, as opposed to just distilling the existence of those crimes by listening to the evidence itself. So they do have that authority among another cabal of states in the United States to return bills of indictment for uncharged offenses.
Well, now it's kind of like a whole brand new case. So, Brian, you think the grand jury got it right? You think they got it right with this new top count?
I think they did, and I think it's because of the statements that we've heard from both the 4-year-old as well as what occurred inside the home. When the 4-year-old tells the parents, she wanted me to go with her, why did he believe that? There must have been some form of words or some sort of words that were communicated to him that by her that made it seem like this isn't just her wanting to come inside and look around. She wanted to go to a separate location. That's the attempted abduction. And then going in and talking to the other children, the question then becomes, did she want to take just one child, multiple children? And so I think especially the abduction charge, which you didn't see earlier on, makes more sense, as Phil put it, that the grand jury is looking at the evidence, digging in, and it might not have been a charge that presented, but the facts lead them to, it looks like she was trying to do just more than harm the child by touching them or speaking to them, but wanted to take him to a different location.
It sounds like you guys are not convinced I was just trying to teach them a lesson defense, although I'm not sure how long that will last. Philip, Brian, great to see you both. Thank you. Everyone out there, thanks for joining us here on Law and Crime Daily. We're going to see you next time as we discuss justice in America.